Indigenous People of Biafra, IPOB, has said that the detained Biafra Republic agitation leader, Mazi Nnamdi Kanu, has not forfeited his rights to defend himself before the Federal High Court sitting in Abuja, after the judge, Justice James Omotosho, ruled on Friday and stated that Nnamdi Kanu's rights to enter defense has been forfeited and thereafter fixed November 20, 2025 for judgment, as Nnamdi Kanu was seen to have staged a defensive confrontation with aggressive loud voice, challenging the court that the federal government allegations against him has no legal basis or any aspect of the Nigerian law that backs such allegations. This, Barrister Aloy Ejimakor, the organizing lawyer for the detained Biafra Republic agitation leader, had on Wednesday said in a written and video statement posted on his X social media account that Nnamdi Kanu is competent enough to defend himself, especially given the political elements in the case which he understands better than any lawyer. In a press release issued and made available on Friday, IPOB, in the statement signed by Emma Powerful, said it strongly condemns the new round of fake news being pushed by certain Nigerian media outlets. The false claim that Mazi Nnamdi Kanu has forfeited his right to defense in the ongoing trial before Justice James Kolawole Omotosho of the Federal High Court, Abuja, is a desperate lie meant to mislead the public and cover up an illegal process. Let the truth be clear: Mazi Nnamdi Kanu has not forfeited anything. What is happening in court is not a fair trial but a political show. Up till today, neither Justice Omotosho nor Chief Adegboyegba San, the government's lead prosecutor, has been able to point to any valid, existing law that Mazi Nnamdi Kanu supposedly broke. Their silence speaks volumes. It is a quiet confession that this entire case has no legal foundation. The core question remains simple: can anyone be prosecuted or convicted without a living law that clearly defines the offense and prescribes a punishment? The answer is written in Section 36(12) of Nigeria's 1999 Constitution. A person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore is prescribed in a written law. This means you cannot charge or convict anyone unless the law exists in black and white. No judge or lawyer can twist that. The Supreme Court has said the same thing many times. In Auko vs. Fagbemi, 1961, AG Federation vs. Abubakar, 2007, and NNPC vs. Fawahinmi, 1998. Where there is no law, there can be no trial, no conviction, and no justice. But instead of obeying this clear rule, Justice Omotosho keeps trying to force Mazi Nnamdi Kanu to open his defense, as if pretending there's a valid case will make it real. This is wrong. It's a misuse of power and a clear violation of fair hearing. You cannot force a man to defend himself against a ghost charge. So we ask again, under which law is Mazi Nnamdi Kanu being tried? What act of the National Assembly defines his supposed offense? And by what right does a judge compel a defense where no offense in law exists? Nigerians deserve honest answers, not propaganda. Everyone should read Section 36(12) and know their rights. It protects all of us from tyranny. Any court that ignores the Constitution becomes part of the problem, not the solution. IPOB fully supports Mazi Nnamdi Kanu's stand in refusing to legitimize this illegality by entering a defense. The truth is unshakable. No valid law supports this case, none whatsoever. Now, Justice Omotosho says he will give judgment without even allowing final addresses from both sides. That's laughable and unheard of in criminal law. If that is truly his position, then maybe he needs to go back to law school and learn what due process means.
Directives of the Supreme Court, judgment in FRN v. Nnamdi Kanu in suit number SC/CR/1361/2022, delivered on the 15th of December 2023. The relief I'm seeking, my Lord, is a very simple. the expunging from the records of this very honorable court the purported plea of not guilty entered by myself, the defendant, here the applicant, on the 29th day of March 2025, the same having been obtained under deception, coercion, and in clear violation of Section 36(6)(a) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and in defiance of the Supreme Court's binding directive in FRN v. Nnamdi Kanu. I'm asking my Lord for an order setting aside all proceedings conducted pursuant to the said defective plea, including but not limited to the scheduling of defense, witness summons, and trial dates, the same being founded on a nullity admonition. An order declaring that the 7th count charge, dated 29th March 2025, disclosed no triable offense known to law, having been founded on repealed statutes, namely the Terrorism Prevention Amendment Act of 2013, repealed by the Terrorism Prevention and Prohibition Act of 2022, and the Customs and Excise Management Act, Cap C45 LFN 2004, repealed by the Nigeria Customs Services Act of 2023, and in flagrant disobedience of the Supreme Court's order for amendment, and order striking out the charge in its entirety for want of jurisdiction, the same being incompetent and void ab initio. An order directing the immediate release of the defendant applicant from custody, there being no valid charge pending before this very court, and such other orders as this very honorable court will deem fit and just to make in the circumstances. It was dated, my Lord, the 6th day of November 2025. Thank you, my Lord.
Yes, and I think Supreme Court said do something, you will do it. And you're just sitting conviction. And you wonder why God cost you this. Useless black man. You don't know what justice means. You have no idea what justice means. You don't know what justice means. Useless black African people. You don't even know what justice. Your constitution says you cannot try anybody unless the law is written. Show me the written law. Show me the written law. I want to know the written law. Talk to me now. Show me the written law. Are you okay? Don't go close. Don't try that rubbish. Don't try it. Don't try it. Don't try that rubbish. Don't try that rubbish. Useless people. You don't know law. You don't know law. Your own constitution you don't respect. Supreme Court judgment you don't respect. Then why are we in the court of law? Why are we in the court of law, I ask? Nonsense. You think Britain can ask you to jail me and you jail me? You are dreaming. You are dreaming. I'm telling you that you are dreaming. Nonsense. Your constitution says you cannot try anybody unless the law is written. Show me the written law. Show me the written law. Don't try it. Don't try it. Don't try rubbish. Don't try rubbish. Useless people. You don't know law. You don't know law. Your own constitution you don't respect. Supreme Court judgment you don't respect. That's why we in the court of law. Why are we in the court of law, I ask?
Good morning, sir.
Good morning.
Yes, I know you attended the proceedings today.
Yes, I did.
For Nigerians to know.
Yeah.
Just a summary of what happened.
Well, what happened in court today, for me, continues to be travesty of justice. I've always said it, that in Nigeria, there appear to be two sets of rules. One for the Igbo man and another for the other Nigerians. This is exactly what I saw in court today. First of all, my name is Honorable Obi Agocha. I represent the great people of Iguano, Umuahia North and Umuahia South Federal Constituency. I am the primary representative for Mazi Nnamdi Kanu. So I'm going to speak to you as a layman. I'm not a lawyer.
Bringing you the news in a more digital way.